You'd be surprised how many people walk into mediation like it's a courtroom, acting tough, talking over people, and trying to win. And that's mistake number one. Mediation isn't a courtroom. It's not about who's louder or who looks stronger or who's right in some cosmic sense. Mediation is about settlement. It's about control. It's your last, best chance to avoid the unpredictability, expense, and emotional wreckage of litigation. But people screw it up badly. So here are 3 mistakes people make during legal mediation that can tank your chances of walking away with a deal you can live with. First up, they treat it like a trial. They go in with binders, witnesses, sometimes even dressed like they're ready to testify. But here's the thing, no one's deciding anything that day. The mediator isn't a judge. They don't rule. They don't impose anything. They try to help both sides see the bigger picture and land somewhere in the middle. If you walk in thinking you're about to give a closing argument, you're not negotiating, you're performing. And that performance costs you leverage. The second big mistake, refusing to show any vulnerability. A lot of people, especially litigants who are hurt, angry, or just feel wronged, go in trying to act invincible. I'm not settling. I'll take this to trial. I don't need a dime. That's bluffing, but it's also bluffing without a strategy. You know what actually gets results in mediation? Controlled honesty, a little openness about your concerns, your goals, your fears. It gives the mediator tools. It humanizes you to the other side. And it shows you're not just playing games. Sometimes the other party won't budge until they hear how the situation has affected you personally. Mediation is one of the only places in law where that kind of human stuff matters. And ignoring it is just a bad strategy. And mistake number 3, and this one's the killer, showing up unprepared. Not legally unprepared. Most people have their lawyer and their case ready. I mean, emotionally unprepared, logistically unprepared. You've got to come into mediation knowing what your real bottom line is. Not just what you want, but what you're willing to accept. You need to know what happens if the case doesn't settle. That's called knowing your BATNA, your best alternative to a negotiated agreement. Without knowing that, you can't negotiate in good faith. You can't make trade-offs. And you can't pivot when the numbers get close. You should also bring food and be ready to sit there all day. People think mediation is quick. It's not. It's war by waiting. You sit around for hours while the mediator shuffles back and forth, delivering offers. You'll hear things that frustrate you, things that feel insulting, offers that make you want to storm out. But here's the truth. If you can stay calm, stay focused, and outlast the nonsense, you might get a deal you can live with. Maybe not love, but live with. And in law, that's a win. Now, just to be clear, some cases should go to trial. Some people walk into mediation thinking they'll be bullied into settling, and that's not okay either. If the numbers are ridiculous, if your case is strong and the other side won't negotiate seriously, walk. You don't have to sign anything, but at least know why you're walking. Don't let ego, miscommunication, or bad prep ruin a real chance to settle. Because when mediation works, it's a gift. It keeps you out of court, out of the news, and out of debt. And here's one more bonus mistake people make. They let their lawyer do all the talking. Look, your lawyer's important, but you're the client. You're the one who has to live with the outcome. Don't zone out while your attorney runs the show. Ask questions. Speak up when needed. It's your life. Own it. At the end of the day, mediation isn't about victory. It's about closure. The smart play is to walk in with eyes open, ego checked, and a real plan. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.